Hi, this is Shannon. This is 5 reasons that you should have a will or a trust instead of going without. The first one is that the rules of intestacy would apply if you don't have a will or trust. And what that means is there's a law in your state that determines who gets your stuff when you die. And for people in second marriages, that can be very different than what you may expect. So there can be a division of your assets with your children, even though you're married to someone currently. The second one is if you have minor children, it's very important to name a guardian in your will. And that should be someone who the father of your children also names, if that's possible. And don't forget to distinguish whether or not you'd want that guardian to be appointed if they're divorced or if one person in that couple has died. So that is a very important one. And then the other thing related to minors is you can put in your will a testamentary trust that sets monies aside for your child so they don't get all the monies at 18. Also, you can avoid a whole guardianship process if you have a testamentary trust in your will, because if you just have a guardianship, your children will receive your assets when they turn 18. And also, there's no way to avoid a guardianship in that situation for the minors. And usually the parent who's living will be the one to kind of manage those assets or ask the court for distributions. And it can be a bit unnerving, especially for people who are divorced. That's the second one. The third one is bond waiver. So if you have a will and you waive the bond for your personal representative or executor, then that means that basically they won't have to post a bond when they file the probate proceedings. And that can be very expensive. So if you had like a $500,000 estate, meaning that your assets were worth $500,000, the bond could be anywhere from like $8,000 to $10,000. So it gets very expensive when we have to post a bond related to an administration. And oftentimes the court won't waive a bond unless there has been a specific waiver inside your will. So that's another reason. And then of course, if you have, let's say your death event is like a car accident and your personal representative or executor has to sue someone, it's very important that that lawsuit, that the personal representative, in a will you can decide who that would be, has all the authority and powers to properly pursue litigation and then to deal with things like business interests or entities. So those types of powers can be put inside of a will. Whereas if you don't have that, then the court relies on the statute to determine what those powers are. Finally, and this is one that people don't really think about that much, but this is elective share. So a lot of people think that, if they have a spouse and they haven't named them on things like their homes or on bank accounts, if you've titled them to pass pay on death, that their spouse won't inherit those items. Like if you said well, I'll just name everything pay on death to my children, so my spouse has their own assets and they won't be entitled to receive any of the assets because I've named it all to pass to my children. That is not necessarily the case with something called elective share, where a spouse can actually take a certain percentage. In Florida, it's 30% of your assets. That might include even half of the homestead value, even if that person's name isn't on the deed. So it's important that you get educated about what elective share is, and there are things that you can put into your estate plan and your trust and in your will to really protect those elective share assets to eventually pass to your children upon the death of that spouse. Okay, I hope this is helpful. 5 things. Take care. Have a good day. I'm Shannon.